Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Lots of things going on as the Biden administration ends its 4 years in office. Looks like regulations are being promulgated on things like administrative closure, and parole is getting pretty complicated. As of this recording, I'm pretty sure that lots of people paroled into the United States will not have an opportunity to renew their parole from those specific countries, but that individuals with pending parole applications may still be paroled in, as the programs themselves are not ending. Kinda confusing. Plus, of course, parole in place remains tangling in the courts. But as I got behind my microphone today, I was wondering, what about DACA? Always DACA. Always a legal fight. Well, the issue went to the Fifth Circuit earlier this week, that is, whether or not federal judges can end the DACA program, or more specifically, whether the state of Texas has authority to challenge it. Looks like based on some of the questioning that old case law in the Fifth Circuit would have probably definitely given Texas standing to challenge DACA. But after the decision U.S. v. Texas, 2 years ago at the Supreme Court when Texas was challenging another prosecutorial discretion program, the Supreme Court said that Texas didn't have standing. You can't force a prosecution arm like DHS to prosecute more people, essentially is what the Supreme Court and Justice Kavanaugh said in U.S. v. Texas. So as Law 360 reports, during oral argument this week, Judge Higginson on this Fifth Circuit panel explained that U.S. v. Texas has, quote, done a huge sea change, end quote, to prior Fifth Circuit precedent allowing states like Texas to challenge things like this. Judge Higginson said that the overarching message of U.S. v. Texas was a need to tie standing to, quote, a history and tradition of courts being empowered to decide cases, end quote, involving U.S. foreign policy, and so asked the judge of Texas, quote, is there any history and tradition of states suing to stop immigration foreign policy, other than in the last 10 years, end quote. Doesn't look like Texas could respond very well to those questions, and we'll see if the rest of the panel agrees with what appears to be Judge Higginson's view that the states don't have authority to challenge DACA. As always, of course, such an important thing like DACA is something that should be decided by Congress, but until they do, here we are, fighting away about standing. This week on the podcast, only 2 cases, not about standing, definitely about asylum, and well, let's do them. Are you struggling to find and hire new talent that you can trust? Does the idea of onboarding, training, and managing virtual staff overwhelm you? Staffy's got your back. Staffy provides top-quality virtual staffing for immigration law firms, complete with HR support to free up your time from the hassles of onboarding, managing, and continuously training your virtual staff. with an entire team of professionals, including psychologists and mindset, task, and performance coaches. Staffy ensures your virtual staff has all the tools needed to help your law firm grow and scale. Visit staffy.cc, that's stafi.cc, and schedule a consultation to claim $500 off your first month of service. Or, of course, click on the link in the show notes. Let us begin with Meza Diaz et al. V. Garland, published by the Ninth Circuit on October 8, 2024. This case is about past persecution. Remanded back to the agency without even oral argument, by the way, because it appears both parties waived oral argument. Call me out, but I'm never waiving oral argument. But hey, it's a win, nonetheless. In fact, maybe more impressive. Miss Meza Diaz is from Mexico, as is her derivative daughter. Their problems with the cartel began in 2000 when Miss Meza Diaz was only a minor. Her brother and grandmother were murdered in Michoacan. 4 individuals were charged and eventually sentenced to 14 years in prison for the murders. So that's actually pretty good in life, but also pretty undermining of an asylum claim, right? Looks like the government acted. Except that Miss Meza Diaz and her family continued to receive phone and mail threats after that. Police patrolled her neighborhood for a while, but then stopped. The callers ramped up their threats against Miss Meza Diaz under the belief that they knew that she had been the one that reported the threats to the police. It got so bad that Miss Meza Diaz and her surviving siblings fled to the United States in 2002, although her mother remained behind. And when the mother stopped receiving threats, Miss Meza Diaz returned to Mexico to be with her common-law husband and their daughters. The husband was then abducted, beaten, and tortured a few years later. He was released when Miss Meza Diaz paid 250,000 pesos. They knew who she was and what had happened to her brother, that is, the people who had kidnapped and extorted her for her husband's return. Miss Meza Diaz was targeted as well, it appears, and the threats continued after. Death threats, including threats about going to the police. The husband fled to the United States a few months after he was released, but Miss Meza Diaz kept receiving threats from the cartel because she stayed behind. So the couple sent their 2 oldest daughters to the United States, both of whom were already U.S. citizens, somehow. In 2016, a group of armed and hooded individuals burst into Miss Meza Diaz's home when she was there with her youngest daughter, telling her that her time had come and she was going to die. She was beaten to unconsciousness. If she didn't pay 1 million pesos within 3 days, they'd kill her and her daughter. Police recommended that she flee Mexico and actually drove her and her daughter to the airport, which is pretty wild. Miss Meza Diaz presented herself at the San Ysidro port of entry with her minor daughter, and she was placed in removal proceedings. Must have been deemed to have a credible fear. Deemed credible in those proceedings, an immigration judge denied asylum. Lots of reasons, but what's important here under the BIA's affirmance was a no past persecution finding. And in any event that Miss Meza Diaz hadn't shown that the Mexican government couldn't protect her, which quite frankly is also wrapped up in a no past persecution finding. And also, that airport thing is quite compelling, no? Right? The police brought her to the airport, telling her to flee because they didn't think they could protect her. Correct. The Ninth Circuit remanded. First, quote, the harms that Miss Meza Diaz and her family suffered, murder, physical assault, kidnapping, a home invasion, and specific years-long death threats clearly rise to the level of persecution under our precedents, end quote. Even putting aside the serious harm and threats that Miss Meza Diaz herself personally suffered, quote, we have consistently held that petitioners whose family members have been murdered, particularly when the petitioners themselves have also suffered physical injury, have suffered persecution, end quote. And threats to the individual can be persecution too, by the way, on their own. And by the way, it doesn't matter to the court that it all happened over a period of 16 years. In fact, that all seems connected to the court. That is, a pattern over 16 years. So the harm is good enough to be past persecution. What about nexus to a protected ground? Still needed always to be past persecution. And of course, it's a particular social group claim. Well, unlike the agency, it was pretty clear to the Ninth Circuit that one central reason for all of this was because Miss Meza Diaz was part of her murdered brother's immediate family. The attackers said, quote, your time has come, end quote, when they invaded her home, for example. More stuff too. Some of it coming from the Mexican police reports themselves. That is the reason that the Mexican police believed Ms. Meza Diaz was being targeted. The Ninth Circuit doesn't believe the agency really considered that important evidence and so is sending it back. The panel does not, quote, attach any significance, end quote, to the IJ's statement that all evidence was considered, when the record and decision indicates to the court that it was not. Remember that one in your appellate briefs. Still though, again, you need to show that the Mexican government was unable or unwilling to protect to establish a past persecution claim. So many elements for people fleeing for their lives to meet, right? Well, to the Ninth Circuit, quote, in instances of police failure to respond to a report of persecution, we have held that a petitioner need not provide evidence that a government is unable or unwilling to control persecution on a countrywide basis, end quote. Home city or home area alone are sufficient, explained the panel. And that seems like a very important standard to me as well. Here, for example, not only did police say that they couldn't assist, but again, they helped Ms. Meza Diaz and her daughter flee Mexico because they believed their safety was at risk. Apparently, the police even, quote, gave her a copy of the police report to present to U.S. immigration authorities, end quote. That report says it's from police, is directed at U.S. immigration authorities expressly, and explains that Ms. Meza Diaz and her daughter were fleeing Mexico in order to protect their safety. More evidence as well. The record shows that the brothers' killers, for example, were recently released, and that police couldn't help during other times. Quote, the BIA made much of the fact that the police allowed her to file a report, of which they provided her a copy, and drove her to the airport in a patrol car. But a copy of a police report and a ride to an airport after urging a citizen to flee the country falls far short of a willingness or ability to control that citizen's persecutors, end quote. Which of course is the government standard for asylum, ability or willingness to control. In any event, Ninth Circuit precedent makes clear that willingness to protect and ability to protect are different things, and you only need to lack one to get asylum in the United States. J.R. v. Barr for that, by the way, episode 20, and an excellent decision for non-citizens if my 4-year-old memory serves me well. If you're ever fortunate to have such an exceptional fact in your client's case, quote, the explicit admission by the police that they could not ensure Ms. Meza Diaz's safety must be given substantial weight, because the question on this step is whether the government both could and would provide protection, end quote. Not to mention what the Department of State reports say about local police and cartel violence in Mexico. Heck, and it's obviously not in this decision, but horrifyingly, The Guardian reported that today, the day of this decision, the new mayor of a town in Guerrero State was decapitated 6 days after taking office. Another quote from J.R.V. Barr, quote, our law does not require applicants to wait until gang members carry out their deadly threats before they are eligible for asylum, end quote. Remanded, all of it. Because, of course, if past persecution is shown on remand, DHS has a burden to rebut. Big case. So congratulations, Marty M. Sproul for petitioner. And that is Meza Diaz et al. v. Garland. Which means we get to conclude with Alvarado-Reyes v. Garland, published by the First Circuit on October 7th, 2024. Short week, not complaining. Currently on an airplane. Well, editing on an airplane, that is. This case is about gang-type asylum claims. Mr. Alvarado-Reyes is the lead applicant in a family of asylum seekers from El Salvador. In El Salvador, he cared for his grandparents, and his uncle bought him a truck to help for this care, which started off the extortion and the threats by MS-13. First, MS-13 members wanted Mr. Alvarado-Reyes to do a little help for them with the truck, driving around MS-13 members and such. When he refused, they said he would pay, that his son would pay, and that they'd rape his wife. The gang made similar threats at least 5 times. Mr. Alvarado-Reyes also received threatening phone calls, anonymous notes too, all the time. His wife experienced some of this too, but mostly in relation to Mr. Alvarado-Reyes and the truck desire. They never went to the police out of fear and fled El Salvador when the threats intensified, with their young child. An immigration judge denied everything in removal proceedings after deeming Mr. Alvarado-Reyes and his wife credible. The harm wasn't bad enough, or for the right reasons, explained the IJ. The BIA affirmed, as did the First Circuit. Despite starting off by saying this, quote, "We are dismayed to note, but feel compelled to mention, that the transcript of petitioner's merits hearing before the IJ is riddled with so many indiscernible notations, so as to render the transcript effectively meaningless and useless to our review of the petition for review," end quote. A problem the First Circuit explains is recurring in cases before it seems, and that violates due process. Quote, "Be that as it may, because petitioners did not present this as an appellate issue, we leave this topic with our concerns noted and move on to the arguments before us," end quote. So, heads up First Circuit practitioners, though? Looks like a indiscernible transcript is a per se winning argument, if indiscernible enough, in the First Circuit. Here the court affirmed on nexus, as admittingly, that's probably usually the hardest thing to show in asylum cases and therefore the easiest thing to deny on. That is, the harm suffered and feared must be on account of a cognizable race, religion, nationality, political opinion, or membership in a particular social group. Here, it's because the proffered particular social group, quote, "Salvadoran men who resist gang recruitment," is not, on this record, a legally cognizable PSG, end quote. Without explaining that it now owes no deference to the BIA's particular social group definition, the First Circuit explains that to be a viable particular social group, a group must be immutable, particular, and socially distinct in the country at issue, requirements from BIA precedent long deferred to by circuits. As relevant here and in the First Circuit, quote, "A group is considered particularly defined where it is discrete and has definable boundaries. It must not be amorphous, overbroad, diffuse, or subjective," end quote. Pretty sure that comes from Chevron deference, though. Just saying. Anyway, no clear benchmarks, explained the First Circuit. There are so many reasons why someone would resist gang recruitment, and actually, the court isn't really even sure what it means to resist gang recruitment. That makes the group impermissibly, quote, "open to varying subjective interpretations," end quote, amorphous and overbroad. Now, there were two other proffered particular social groups, quote, Reyes family and Salvadoran men, end quote. But the IJ, BIA, and First Circuit don't believe that those groups, even if proper particular social groups, were one central reason for the harm, so no nexus. It was more about Mr. Alvarado-Reyes owning a truck and his refusal to help MS-13. Anything else was incidental, tangential, or superficial, and so not a nexus. It was clear to the court here that the gang would not have targeted the family sans truck, and quite frankly, all agree, in this case, that men and women alike are targeted in El Salvador. So, undermining of those latter two particular social groups. Withholding of removal and Convention Against Torture protection summarily denied too, or that is to say, denial affirmed. The First Circuit concluded by rejecting Mr. Alvarado-Reyes' argument that the BIA isn't allowed to affirm an IJ without opinion, as the BIA so often does. The court has said this is fine multiple times, and in any event, quote, "The BIA enjoys a presumption of regularity when it acts officially, so an affirmance without opinion does not necessarily mean the BIA failed to engage in a fulsome review of the record or offer a rational explanation for its conclusion," end quote. The First Circuit concludes by stating such, quote, "We recognize, as demonstrated by petitioners' statements and the voluminous country condition evidence in the record, that rampant gang violence leaves Salvadorans in particularly dire straits with little to no recourse. Nevertheless, on this specific record, there is nothing we can do about it for petitioners," end quote. And that is Alvarado-Reyes v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook @Immigration Review, or send us a tweet @ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.